Let's take a look at due process. Agency officials act as lawmakers, law enforcers, and judges. Agencies officials, however, possess a considerable amount of diverse authority. Much of that authority is discretionary. Agency officials do not have carte blanche authority, however, over the people and businesses that they regulate. Many rules limit their discretion. Many of these rules come from legislative bodies and agencies themselves, but the fundamental law requiring fairness is the Constitution. There are two constitutional fairness protections, due process and equal protection. The Fifth Amendment of the Constitution of the United States provides that no person shall be deprived of life, liberty, or property without the due process of law. As is true of all of the rights in the Bill of Rights, the Fifth Amendment applies to actions of the federal government, but not to state action. The 14th Amendment, one of the three post-Civil War amendments, contains a second due process clause that applies specifically to the states. The precise meaning of due process is not self-evident and continues to evolve. Whether a fair process necessarily includes the other rights found in the Constitution, particularly those in the Bill of Rights, was unclear for years. Intended to prohibit states from discriminating against residents of other states, the Privileges and Immunity Clause protects the right to travel within the states and take up residence and citizenship in another state. Where the Privileges or Immunity Clause fail in protecting individual rights, the Due Process Clause are robust. Due process is a broad concept that's intended to protect people from arbitrary government conduct. The Due Process Clauses mandate that state and federal government treat all persons with a minimum amount of fairness when taking one of the three interests from them. The three interests protected by due process are life, liberty, and property. Procedural due process describes the steps that must be taken by a government before it can deprive life, liberty, or property. Three interests are protected by due process clauses: life, liberty, and property. While life is self-evident interest, the definitions of liberty and property are more complex. Agencies rarely perform acts that threaten life, although a few exceptions exist. Life may be threatened by the termination of gas or electric service in the winter, as an example. The Supreme Court has also recognized that terminating a needy mother's welfare benefits may be life-threatening. If life is threatened by agency action, due process must be afforded to the threatened person. Liberty interests are also protected by due process clauses. Liberty encompasses a multitude of personal freedoms. The right to move about as one pleases without governmental interference is an example. This is not particularly relevant to administrative law because agencies do not normally restrain or incarcerate people. However, a few exceptions can be found. The most substantial expansion of liberty under the due process clauses has been in matters of personal privacy and autonomy. Liberty interests are not only physical in nature, but more abstract rights are also protected. A person may have a property interest in tangible or intangible property. Automobiles, homes, money, and jewelry are examples of tangible property. Obviously, if an agency attempts to take a person's tangible property, the agency must afford due process. Less obvious are many intangible property interests that people hold, such as an interest in receiving government benefits or entitlements. If it's possible, therefore, for a person to have no right to a benefit from the government, but to have a protected interest in that benefit once the benefit is created. Once employed by the government, however, a non-probationary employee has a property interest under due process clause in his or her employment. A person may also have a protected interest in attending a public school, college, university, or other educational program. Once it's determined that life, property, or liberty interest is being affected, due process must be afforded. Generally, due process requires that the affected person or entity be provided with a notice of possible deprivation and a hearing. The form of notice and the hearing varies, depending on the facts of each case. due process is a flexible concept adapting to the facts. Courts employ a cost-benefit analysis when deciding what procedure must be afforded. Due process requires notice and an opportunity to respond. What must be determined is whether a person is entitled to notice before or after some governmental action is taken and the type of response that must be permitted. Will a simple informal presentation to an agency official satisfy due process, or must a full evidentiary type hearing be conducted? These are not easy questions to answer in all instances. The interests of the individual in receiving extended procedural protections are weighed against the interest of the government in minimizing the process. The risk of an erroneous deprivation of interest through the procedures used and the probable value, if any, of additional or substitute procedural safeguards is considered. Said another way, the harm and cost to the government of providing additional process must be weighed against the harm the individual will suffer if not afforded additional process. From this balancing, the determination of what procedures are used is justified and made. The right to notice is central to due process. Notice is an aspect of due process and has two prongs. First, an interested person is entitled to notice of what an agency is about to do, or in some instances, what's already been done. This may include the basic facts and charges upon which the agency is going to act. The second prong is notice of the date, time, and location of a hearing. This is also required by the APA. Notice of a hearing must be timely. Due process does not specifically require a certain period of time. Rather, notice must simply be sufficient to allow a person to prepare for a hearing. In some circumstances, an agency may take summary action, usually to protect the public health and safety. In such instances, due process may not require pre-action notice or hearing. When this occurs, though, there must be immediate post-action notice and a hearing. Hearings take many forms. Courts use the cost-benefit analysis when determining exactly what must be done to satisfy due process. Where, when, and what type of hearing is required by due process clauses before a life, liberty, or property interest may be taken by the government. First, due process requires that hearings be held in such a place that those interested will not be severely burdened by appearing. Another important question is what type of hearing must be considered to satisfy due process. The due process clauses do not require trial-type hearings in all cases. In fact, what is required differs depending on the facts of each case. In all cases, the procedure must be fair. In some circumstances, a person may be entitled to an oral hearing before an administrative law judge. In others, an interested party may be limited to submitting a written argument. Even when oral hearings are held, the due process clauses do not require that trial-like procedures be held. In reality, many administrative hearings are informal meetings between agency officials and individuals, without attorneys and unbounded by rules of procedure. Whether a party is entitled to an oral hearing depends largely upon the issues to be considered. If the issues in dispute are factual, then the parties must be given the opportunity to present their side of the story, call witnesses, and cross-examine those who testify conversely to their position. There's no need for an evidentiary hearing, however, when the facts central to the case are test results or other scientific information. There's also no requirement of an evidentiary hearing if legislative rather than adjudicative facts are found. The distinction is a matter of scope. If a matter has a factual element but the outcome is obvious, then due process may not require an oral hearing. Agencies make many decisions and take many actions that do not fall squarely within the definitions of adjudication or rulemaking. These actions may nevertheless be limited by due process concerns. The due process clauses also mandate that agencies permit the representation of counsel in some administrative hearings. Even the right to have retained counsel is not extended to all administrative hearings. If the purpose of the hearing is to find facts or to discuss complex issues of law, there's likely a right to have counsel present. It's been held that there's no right to counsel at prison disciplinary hearings, some probation revocation hearings, or school suspension guidance conferences. Issues of punishment and rehabilitation are considered such proceedings, and legal counsel would be of little assistance. The 14th Amendment declares that no state shall deny any person within its jurisdiction the equal protection of the laws. This is the Equal Protection Clause. The Equal Protection Clause provides that no state will deny a person the equal protection of those laws. The Fifth Amendment to the U.S. Constitution has been interpreted to extend the same limitation to the federal government. The Supreme Court has determined that even though this language does not appear in the Fifth Amendment, its prohibition is implicit in the Fifth Amendment's Due Process Clause and is applicable to the federal government as well as to the states. Equal protection is concerned with laws and actions that classify and treat people differently. Equal protection is important to administrative law in two respects. First, the Equal Protection Clause applies to all laws, both state and federal, regardless of their source. Second, it's possible for a law to be consistent with equal protection, but an agency's enforcement of that law to violate equal protection. Not all classifications are violations of equal protection. Actually, most classifications are necessary and lawful. Classifying people is inherent in the lawmaking process. What law or action violates the Equal Protection Clause? The Supreme Court has developed a three-tiered test to determine if equal protection has been violated. This test is also used to determine if substantive due process has been violated. Hence, the test is used if the government classifies people for purposes of regulation and when the law encroaches upon a constitutional right. A law may violate equal protection if it's either overtly or covertly discriminatory. A contemporary challenge in equal protection law concerns government programs that advantage historically disadvantaged groups. These policies, commonly known as affirmative action, are in some people's eyes violative of equal protection. To the supporters of such policies, they are a means by which greater equality can be achieved. The 14th Amendment is not the only constitutional provision that mandates equal protection. The 15th Amendment provides that the right to vote shall not be denied or abridged by the United States.